Good afternoon, everyone, and thank you for joining us for this Dental Board of California meeting. I am Dr. Alan Felsenfeld and serve as the president of the board. Today is Monday, March 14th, 2022, and this board meeting is being held via WebEx. In accordance with Government Code Section 11133 and Governor Gavin Newsom's Executive Order N-1-22, this meeting will be held by teleconference with no physical locations. For all those who wish to participate, please log on to the WebEx website provided on the posted agenda for this meeting. Instructions to connect to the meeting are provided on the agenda. The preferred audio connection is via telephone conference and not the microphone and speakers on your computer. The phone number and access code will be provided as part of your connection to the meeting. Since this meeting is being conducted via WebEx, I will ask all board members and speakers to announce themselves by name before speaking for clarity of the official record. All board members are able to unmute themselves to speak during the meeting. Please place yourself back on mute when not speaking to reduce background noise for all participants. When making a motion, please use the raised hand feature to be called upon, and then verbally state your motion or second so staff can identify the motion and second for the meeting record. During a discussion on an agenda item, please use the raise hand feature if you wish to speak, and I will call on you in order. Following such online meeting etiquette will ensure the best audio quality for everyone. During each call for comments from board members and speakers, we will ensure that all comments that can be accommodated are heard before proceeding with the agenda. This is an official business meeting of the Dental Board of California. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. The Dca Moderator will explain the process for providing public comments shortly. When called upon, the moderator will give the individual permission to unmute themselves, and they will have 2 minutes to make public comment. The moderator will audibly announce when 30 seconds remain to conclude the public comment. After the 2 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. Depending on the number of people who would like to testify on a particular agenda item, a total time limit may be imposed at the discretion of the chair. We ask all speakers to please stay on topic and not repeat testimony already provided. If you agree with the testimony already provided, please state your name and that you are in support of any comments previously provided. All comments must be germane to the topic being discussed. I would now like to ask the Dca moderator to explain how public comments will be taken during this WebEx meeting.
Thank you. This is the moderator. To facilitate public comment today, we will be utilizing the WebEx question and answer feature, which you will hear me refer to as the Q&A. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," or the word comment into the question box, which is typically located in the right corner of your screen. You'll be looking for a question mark inside of a square icon, and when you click on that icon, that will open that question box for you to utilize. For our call-in users today, you will be able to raise your hand by dialing *3. I will call on individuals in the order that they are received, and I will give each individual permission to unmute your microphone. When I let you know that you can unmute your microphone, you will be looking for an Unmute Me button that will appear at your end of the screen. When you click on that button for the first time today, you may hear a brief recording by WebEx. You'll need to wait for that recording to end before you begin speaking. Each individual will have 2 minutes to make their comments. At the conclusion of the 2 minutes, I will mute your microphone and move on to the next member who has a comment. I will be providing a 30-second warning before your time expires. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the board. Such inquiries submitted using this feature will not be answered. When making your comment, please make sure the comment is directed at the host in the drop-down. While you are free to express criticism or negative views, For the sake of the members of the public participating on the call, please do not use profane language when making public comments to the board. I will provide a brief reminder of this approach at the start of the public comment items. And finally, I'd like to remind board members or senior staff that when you're not speaking, please mute your microphone. If I do detect background noise during the meeting as a result of unmuted microphones, I will either provide a brief, friendly reminder to mute your microphone or mute your microphone from my end. And with that, I will turn the floor back over to President Felsenfeld.
Thank you, Moderator. I would like to call the meeting to order and ask the Board Secretary to please call the roll.
This is Dr. Sonia Molina, Board Secretary, and I will now call the roll. Chan?
Jan here.
Chan present. Felsenfeld?
Felsenfeld here.
Felsenfeld present. Larin? Larin present. Mackenzie?
Mackenzie here.
Mackenzie present. Medina? Medina present. Mendoza?
Mr. Mendoza is not attending today, Dr. Molina. He's
Okay.
excused.
Molina present. Montel? Montel present. Morrow?
Morrow present.
Morrow present. Olagi? Olagi present. Pacheco?
Pacheco present.
Pacheco present. And you? You present. We have a quorum.
Thank you, Dr. Molina. We will now move on to Agenda Item 2, Public Comment on Items Not on the Agenda. As we move into the public comment period of items not on the agenda, please note that in accordance with Government Code Section 11452.10, Subdivision A4, the Board, as the adjudicator in administrative discipline cases, cannot take public comment on any pending disciplinary matter. Accordingly, if an individual makes comments on a pending disciplinary matter, the individual's microphone will be muted. Of course, if the public comment raises concerns with the statutes under the Dental Practice Act, the board may choose to discuss those matters at a future board meeting. As always, the board will not respond to any questions asked during the public comment period. Are there any public comments? DCA Moderator, please facilitate the line for public comment.
We've opened that Q&A panel. If you'd like to make a comment on items not on today's agenda, please locate that Q&A icon in the bottom right corner of your screen. Click on that to open the text box. In that text box, you can type the word comment or the phrase "I would like to make a comment" and submit that to the host. For our call-in users, you can raise your hand by pressing *3, and I will locate you in our list that way. Our first comment today comes from our calling user. Calling user number 8 is how you're identified. I've sent a request to unmute your microphone.
Hi, this is Are you calling on me? This is Maura Tuso.
Yes, we can hear you.
So, I'm still trying to learn how this works. I had appeared at your meeting, a public meeting, on November 18th, 2021.
Go ahead.
I don't have the WebEx. I don't have that, so that's why I'm calling in. I don't know. The automated thing just spoke. I had been trying to just get questions answered, and if not appropriate during the meeting, if one of the board members or anyone at the dental board could respond, reach out to me after, but no one has. That has not happened. I found out, so you guys, my license was revoked on August 16th, 2019. I found out by accident that I could have applied to reinstate my license after 1 year when I was being told in writing.
Doctor, this is not on the appropriate time to do it. Ms. Wallace is aware of your issues, and she will be responding to you directly.
But she never does.
She's doing it as we speak. As we speak, she's going to respond to you. Thank you.
Thank you. And not seeing any other requests for comment, would you like me to close the panel?
Yes, thank you.
It is closed.
We will now move on to agenda item number 3, discussion and possible action on the February 10th, 11th, 2022 board meeting minutes. Before we take board member discussion, it's my understanding that Ms. Wallace had a correction that she would like to offer. Am I correct in that, ma'am?
Dr. Felsenfeld. On page 5 of the meeting materials, under agenda item 4, there is a word he that should be inserted. It should read, President Felsenfeld reported that he attended the January 22nd, 2020 meeting.
Yes, I did. Okay, thank you very much, Ms. Wallace. That's an editorial comment. Are there any other comments about the minutes? Seeing none, is there a motion to accept the minutes? Please raise the hand to do that. I see. Ms. Welch, did you want to make a comment on the minutes? I'm sorry, I see your hand is raised.
Thank you, Dr. Felsenfeld. Yes, I do. On page 5 of the meeting materials, it's page 2 of the meeting minutes. Go down to agenda item 4, the heading, first line under the title. It says President Felsenfeld reported that we to insert he attended.
Oh, Ms. Welch, Ms. Wallace just told us that, so we have that. Thank you.
Thank you.
Okay. Are there any other comments? If not, Dr. Yu, I believe you have your hand up. Motion to
Pass.
to accept them. To accept the minutes. Is there a second? Ms. Pacheco.
Second the motion.
Thank you. If there's no further discussion, the board secretary will ask for public comment, and then the board secretary will call the roll. Any public comment?
We've opened that Q&A panel. If you'd like to comment on the motion before you, please click on the Q&A icon, type the word comment or the phrase I would like to make a comment into the text box and submit that to the host. Our call-in users may dial *3. Call-in user number 8, I've sent the request to unmute your microphone.
Yeah, hi, sorry. So this is more so I also have a question about when I spoke at that meeting, are public comments noted formally?
They are not. They are noted for the record, but they're not in the minutes.
They're on the record, but not on the minutes. So if I had a question about how I report Timothy Martinez, I'm sorry.
Dr. Tuso, once again.
How do I bring up a question to address at a meeting? How do I do that? Can someone tell me the process? I have not received any communication from Ms. Wallace.
All right.
I was misinformed and other
Tuso,
witnesses were misinformed.
Dr. Tuso, you may bring up anything at a meeting, either under the section where it says items that are not on the agenda. You can tell us what you'd like to hear. We're not going to take that up under the meeting at this time because it has to be put on a future meeting agenda. Or if you make a comment here that may be pertinent to a future meeting, we can do the same. If you have a personal issue, Ms. Wallace is aware of it and she will respond to you this week, I have been told.
Thank you. And this is the moderator. I do not see any other requests for comment. Would you like me to close the panel?
Yes, please. We are now voting. Dr. Molina, if you'll be kind enough to take the roll on item number 3 and vote on.
Yes, so the motion is to accept the minutes from February 10th through the 11th.
It was Dr. Yu and Ms. Pacheco. Dr. Yu made the motion and Ms. Pacheco did the seconding. Dr. Yu, Dr. Yu, your hand is still up. Did you forget to put it down, or do you have something you want to say before we vote? We're good. Thank you. Go ahead. Go ahead, Dr. Molina.
Dr. Chan.
Aye.
Felsenfeld.
Felsenfeld, aye.
Felsenfeld, aye. Larin.
Larin, aye.
Larin, aye. Mackenzie. Mackenzie, aye. Medina.
Medina, aye.
Medina, aye. Mendoza, absent. Molina, aye. Montel.
Montel, aye.
Montel, aye. Morrow.
Morrow, I.
Morrow, I. Olagi. Olagi, I. Pacheco.
Pacheco, I.
Pacheco, I. You.
UI.
You, I. Motion passes.
Mr. Molina. We now move on to agenda item 4, discussion and possible action to consider comments received during the 45-day comment period and proposed responses thereto for the board's rulemaking to amend California Code of Regulations, Title 16, Sections 1021, 1043, 1043.1, 1043.2, 1043.3, 1043.4, 1043.5, 1043.6, 1043.7, 1043.8, 1044, 1044.1, 1044.2, 1044.3, and 1044.5, 1070.8, adopt sections 1017.1, 1043.8.1 and 1043.9, 1043.9.1, 1043.9.2, and repeal section 1044.4 relating to the SB 501 anesthesia and sedation rulemaking. Before we begin this, I want to do two things. First of all, this is going to be the bulk of our work today, I suspect, and we want to keep it in an orderly fashion because what we're trying to do is facilitate the regulations which will allow members of our dental licensees who are able to do anesthesia to continue to do that. We are working under a little bit of a deadline for that because we are going to have people who won't be able to do what they are based on where we are. I'm also going to ask Ms. Shields, who is our regulatory attorney, if she would like to introduce this and explain where we are, in as much as we have not had a rulemaking package of this size in a long time, and it might be good for the newer members and even those of us who have been around for a while to get an understanding of what we are trying to do today, what we can do today, and what we cannot do today. Ms. Shields, if you will.
Thank you, Mr. President. Can everyone hear me okay?
We can now. Yes, ma'am.
Okay, great. Just for purposes of introduction, my name is Christy Shields. I'm an attorney in the Department of Consumer Affairs, Legal Affairs Division. I joined the department in 2000 after having worked in the private sector for 4 years and having served many clients as board counsel, including the dental board from 2009 to 2012. I've recently been assigned to assist the board with regulations development from our office's recently formed regulatory review unit. So with that introduction, let's move on to the current regulatory proposals before you. We have 2 today, one that's proceeding through the regular rulemaking process for agenda items 4 and 5, and one through the emergency rulemaking process potentially for agenda item number 6. A regulation is any rule, order, or standard of general application or any amendment adopted by any state agency to implement, interpret, or make specific the law enforced or administered by it. When adopting regulations, every state agency must follow the rulemaking procedures in the Administrative Procedure Act, and that's contained at Government Code Sections 11340 and following. The Office of Administrative Law, or OAL, as you'll hear referred to frequently in discussions about rulemakings. The Office of Administrative Law is the agency that is responsible for reviewing and approving all regulations for state agencies in this state, including the dental board. So OAL will review regulations based on the following 6 standards. Authority, which means the provision of law which permits or obligates the agency to adopt or repeal a regulation. Number 2 would be clarity, which means that the regulation must be written or displayed so that the meaning of regulations will be easily understood by those persons affected by them. Number 3, consistency, which means that the regulation must be in harmony with and not in conflict with existing statutes or other provisions of law. Number 4, non-duplication, means that a regulation does not serve the same purpose as another federal or state statute or another regulation. Number 5 is reference, means the identification of the exact law that you're actually interpreting in the regulation. and necessity, which is the standard that is probably the most identified issue in rulemakings, which means the record of the rulemaking proceeding demonstrates by substantial evidence the need for a regulation to effectuate the purpose of the statute being administered. So I've asked staff to provide you, and I hope, yeah, it's up. Thank you. I hope everyone can see it. It's a little grainy on my end, but this is a chart that the Office of Administrative Law puts out that describes generally the rulemaking process. And I just want to go over very briefly with respect to this particular rulemaking. So if we look at the top, you'll see that, yeah, it's a little bit unclear. So if you could zoom out a bit and see if it clarifies the text on the poster, that would be great. Yes, much better. Thank you. So if we look at the chart at the top left corner, you'll see that the rulemaking process really begins with the grant from the legislature, the enactment of a statute that authorizes the board to adopt regulations. And if you recall, we're here because in February 2016, Senator Jerry Hill, chair of the Senate Business and Professions and Economic Development Committee, was made aware of a tragedy in which an otherwise healthy child died after receiving general anesthesia at a dentist's office. He notified the board of his concerns about these issues and asked the board to investigate whether California's present laws, regulations, and policies were sufficient to protect the public. In response, the board president appointed a two-person subcommittee to work with staff to research this issue and conduct a study. The study was released in 2016, in December, and based upon that study, Senate Bill 501 was enacted in 2018 and became effective January 1st, 2022. That law repealed existing articles in the Dental Practice Act involving anesthesia and sedation and enacted new articles affecting the use of deep sedation and general anesthesia, moderate sedation, and pediatric minimal sedation for dental patients in Articles 2.75, 2.84, and 2.87 of the Dental Practice Act. The board has been advised that no new permits can be issued or renewed until these regulations are adopted. So as a result of these changes, the board has provided this proposal to implement Senate Bill 501. These changes require things like updating terminology, setting new competency requirements for permit holders, including those for the general and moderate sedation, general anesthesia and moderate sedation permits, prescribing new forms, and setting new fees to process applications for each type of permit or endorsement authorized by Senate Bill 501. The Dental Board is authorized by law to adopt regulations for the administration of the Dental Practice Act. So if we look at the next building icon on the top of the page, you'll see that the legislation is taken by the state agency, it's analyzed, and that's what your staff have done here to address the problems I just mentioned, the development of new terminology, forms, fees, and criteria for competency requirements, how to implement those requirements. And that is where the preliminary activities of developing regulations occur. They occur at meetings, they're discussed, which they have been. And at your November board meeting, the board was provided with the initial rulemaking documents for discussion. So as we discussed previously, the board is authorized through Senate Bill 501 to implement these changes, and the specific rulemaking authority is contained in Section 1614 of the Business and Professions Code, which authorizes the board to adopt regulations for the administration and enforcement of the Dental Practice Act. So as we discussed, what the rulemaking process does is it takes a general statute and makes the statute more specific, but it does have the effect and force of law. So for an example, in Business and Professions Code Section 1646.2, a dentist who desires to administer or order the administration of deep sedation or general anesthesia shall apply to the board on an application form prescribed by the board. So there you have an example of a general legislative grant of authority to the board. And then it's up to the board to determine what that form contains and the contents of that form, and how applicants, what they need to do to comply with those requirements. And since the form covering the requirements is not currently in regulation with respect to the contents and the requirements of Senate Bill 501, the board's current proposal before you sets forth those requirements in section 1043.1. So that's an example of how you take the law that has been given to you generally and you make it more specific, more clear with respect to the regulated community. And so those issues were discussed, and the proposal was discussed at the November board meeting. And at the board meeting, the board authorized the executive officer to initiate a rulemaking to implement these changes. So then in response to that directive from the board, the following documents were posted on the website. So you'll see on the chart in front of you, the 3 documents that are required to be posted and mailed. Well, actually the text is in the notice are required to be mailed, but all 3 of these documents, the notice of proposed rulemaking, the initial statement of reasons, and the text of regulations are required to be posted and filed with the Office of Administrative Law for publication. The notice is published. And once that begins, that opens the rulemaking process formally. So when you delegate to your executive officer the authority to initiate a rulemaking, this is what occurs. And then the notice and proposed rulemaking initial statement of reasons in the proposed text are posted to the regulated community and the public for 45 days. Changes to proposed text are required by law to be shown in underline for addition of new text and strike through for deletion of existing text. So if we look at the text in the meeting materials starting at page 352, you will see that the text that's existing is not underlined. So anywhere where you see text that is not underlined or is struck through, that is existing text that has already been adopted by the dental board. And the only things that are being changed are things that are being shown and underlined for new concepts, new text, and strike through for deletion of things that the board thinks needs to be removed because it's either inconsistent with the statute or for other reasons related to implementation of SB 501. So then that was published, like I said, for 45-day written public comment period, which ended on the 15th. So you'll see in the green bubble there that the notice was published, it was issued, a public hearing was requested, and it was held on February 16th to take additional public comment. So we have the notice, the publication, the public hearing, and so that takes us to where we are today, which is that green box that says agency considers comments. So agenda item 4 is where we are in the process to consider comments that were submitted by the public during the written comment period. And that includes the hearing on the 16th. As a reminder, public comment closed at the hearing on the 16th. So my recommendation is that you do not entertain any new comments on this agenda item for this item. Doing so will require the board to reopen the public comment period and delay the rulemaking. This board meeting item is simply to discuss the comments already received and whether to accept the comments and make further modifications to the proposed text or to reject the comments. So on the box below where it says changes made to regulations, so based on whatever decision you make today, if you decide to make changes that are related to the originally noticed text, and remember that's things that are in strikeout, then if you have any changes that you want to make in response to comments that are related to these changes, then you would do a 15-day comment period notice with modified text, which the staff has included as agenda item 5. And also you could make any, grammatical, non-substantial, technical cleanup changes at the same time. And so you'll see in this proposal, that there were some technical cleanup suggestions made by the public and also by staff, and that is listed in agenda item 5. But there were also some substantial changes that are recommended in response to comments that were received. And because they're substantial, meaning they do affect right or responsibility or how the law is interpreted, you will need to do a 15-day notice to make these changes. So again, generally we look at what was struck out or underlined in the proposal for guidance on the scope of your rulemaking. If it's a comment that you received that's not related to these changes that were originally noticed, then it's considered what OAL, and you'll see to the left of that box, major changes. So when there's a major change that departs from the original subject matter, then you have to start the rulemaking over again with a new 45-day public comment period and publication in the notice register. So again, that would further delay. So we typically recommend, if you can avoid it, try to stick to what was changes that were, that are sufficiently related or non-substantial to the original rulemaking process, so that you can complete your rulemaking if timeliness is an issue. And then, so like I said, in agenda item 5, staff have recommended that you accept some comments and also make other technical cleanup changes. So if you go further down, if you went down the route of substantial and sufficiently related changes, you did your comment period, there would be additional 15-day notice to the public, and the comments would be supposed to be related directly to the changes that are made in the 15-day notice. So not going over the prior changes, all of the prior changes that were originally noticed, just the changes that were made in the 15-day modified text notice. So that's double underlined and double strike through changes. If after sending out the 15-day notice, no further adverse comments are received, then you'll see that the agency's rulemaking would proceed to the right to completion for final statement of reasons. The summary of the responses to comments are made, and that is all filed with the Office of Administrative Law for review. If adverse comments are received during the 15-day notice of modified text period, then those comments will be brought back to you at a future board meeting for decision. Are there any questions from the dental board members before I turn this back to the board president?
Thank you, Ms. Shields. I don't see any raised hands, so I'm assuming that they are without any questions at the time. So we will continue on, and thank you for your comments. This is a very complex process, obviously, and we want to get it as right as we can. So I will ask David Brueggemann, who is our legislative and regulatory specialist, to introduce this agenda item and explain the comments and the staff reactions to the comments about whether they should be accepted or rejected. Mr. Brueggemann.
Thank you. This is David Brueggemann, and as our president indicated, I'm going to be reviewing the comments that were received both in writing and the comments that were made at the hearing on February 16th. As we review these comments, I'm going to explain both the proposed stance that staff is suggesting, as well as the rationale behind that. You'll find that several comments were repeated by more than one individual, and as we go to subsequent instances, I will refer back to previous comments and our responses for those previous comments. Once we've completed review of these comments, the board can consider one of two options. If the board members agree with the staff recommended responses, they could move to direct staff to proceed as recommended, to accept or reject comments as specified, and provide the responses to the comments as indicated in the meeting materials. If, however, the board members have any edits to the recommended responses or disagree with staff and wish to accept any comments or make any other changes to those responses, they can move to direct staff to accept the following comments and make the following edits to the text. And you would list whatever those edits that you wish to make would be. Motion would continue, but to otherwise proceed as recommended to accept or reject comments as specified and provide the responses to the comments as indicated in the meeting materials. Once I've done the review, we'll come back and revisit this motion language. But for now, we're going to focus on the comments. Agenda item 5 will go to the proposed recommended changes to the text. But for the comments, these are available in our meeting materials, and they start on page 36. On page 36, the first comment section is indicated as Section A. It's an email from Lois Richardson, and in this email, they make 3 specific comments, and it's related to sections 1043B, 1043.9B, and 1044A. Each of these comments refer to each of those sections. The first comment is that the Joint Commission on Healthcare Organizations now operates under the name the Joint Commission. It recommends we change the reference to the Joint Commission. The second comment is that the agency responsible for licensing hospitals in the state of California is now the California Department of Public Health and no longer the California Department of Health Services. That's our second comment. And the commenter also recommends substituting the word that for the word which when it follows the phrase treatment facility in each of these sections. And again, that's section 1043B, 1043.9B, and 1044A. The staff is recommending that we accept these comments. Under Government Code section 11346.8, subsection C, the board may make changes to the originally proposed regulatory language that are not related to the original proposal without further notice if the proposed changes are non-substantial or solely grammatical in nature. And again, we're dealing with a change in the name of the Joint Commission. We're dealing with a change in the agency responsible for licensing hospitals, updating that because that change took place since we last visited these regulations. And then that third comment is a strictly grammatical comment, and so that is why we're recommending that the board accept those comments. The next section of comments starts on page 37, and commenter Mary Wilson provided written comments to the board and also provided a written transcript of her remarks to the board at the hearing. I'm going to deal with her written comments first and then her hearing comments. So in written comments from January 24th, the commenter suggested that we define outpatient in section 1043B, subsection B, for the purposes of determining when a general anesthesia permit is required as follows. That it should read, for purposes of this article, outpatient means a patient treated in a treatment facility which is not accredited. I'm sorry, I misspoke. The commenter is requesting that the board take into consideration the language of outpatient as referring solely to a dental office. This would leave ambulatory surgery centers exempt from the regulatory requirements. So the staff is recommending that we reject this comment. And specifically here, the change would be to section 1043B, which was originally noticed in this rulemaking package without any changes to the originally adopted text. So again, in this particular situation, making a change to that section would require the additional 45-day notice. And because they're making a change, suggestion for a change not sufficiently related to the originally noticed regulatory proposal, and we would have that additional longer notice period, this would put at risk the ability of current general anesthesia permit holders to renew those permits in a timely fashion. Now, the same commenter, as I said, also provided comments during the hearing, and those comments are on page 38. there were two basic comments. The first comment was to renew the request to revise the outpatient definition to include an exemption for an accredited Medi-Cal certified ambulatory surgery center, and that the outpatient definition referred just to the dental office. Her second comment was to request that an accredited Medi-Cal certified ambulatory surgery center be included within the acute care facilities in Section 2827. We believe she was referring to Section 2827 of the Business and Professions Code in reference to certified registered nurse anesthetists. And we are recommending that we reject both of these comments. Staff is recommending rejecting both comments. In the case of her first comment, again, we revisiting the outpatient definition, we reject that as not being substantially related to the current rulemaking. As to the revisions for Business and Professions Code Section 2827, this is not a part of the Dental Practice Act. And in this particular case, the board is not going to have sufficient authority to make changes not only to statute, but to statute that is outside of the Dental Practice Act. Our next commenter is Kenneth Pearson, and his comments are on page 39. They indicated that they believe an ambulatory surgical center should be allowed to contract with any properly licensed anesthesia provider, whether it's a dentist with an anesthesia permit from the dental board, a medical anesthesiologist with or without a permit from the dental board, or a certified registered nurse anesthetist licensed in the state of California. Commenter also requests that these surgical centers be exempted from AB 501. We recommend that these comments be rejected, as we've indicated in the prior comments. The request here is for amendments to an existing section of regulations that is not within the scope of the current rulemaking. And again, also, there are requests here that will essentially require statutory changes, which is also outside of the scope of the proposed rulemaking. The next set of comments comes from Jeremy Pearson. These are also starting on page 39. A lot of the comments restate arguments raised by Kenneth Pearson. But in addition, the commenter is stating that the regulations associated with this bill that are being written are, in their perspective, attempting to allow the board to overstep their regulatory authority, and indicates that they believe that ambulatory surgical centers as outpatient treatment centers should be exempted from board regulations. Staff is recommending that we reject these comments. The board is not asserting through this rulemaking any authority to regulate ambulatory surgical centers. However, we do indicate, the board has authority to regulate any dentist working in an ambulatory surgical center. And so we would have statutory authority over dentists ordering the administration of or administering general anesthesia or deep sedation, moderate sedation, oral conscious sedation for adults, and pediatric minimal sedation to dental patients on an outpatient basis, which would include treatment at an ambulatory surgical center, as long as it's not a general acute care hospital. These would be considered outpatient settings by law. The existing section of the regulations, 1043 subsection B, establishes, again, that outpatient treatment would not include treatment in a general acute care hospital accredited by the Joint Commission or licensed by the California Department of Public Health. And this regulatory proposal does not affect the current application of our board regulations to dentists working at ambulatory surgical centers. As we've described in responses to previous comments, to the extent that this suggestion is to make amendments to regulatory section 1043B or to the relevant parts of the Practice Act, we're recommending rejecting it as not being sufficiently related to the rulemaking, or that it would require statutory changes beyond the authority of the board in this rulemaking. The next set of comments comes from Alan J. Vallerine. They start on page 40. The commenter is basically requesting that state licensed and accredited ambulatory surgical centers be exempt from the proposed regulation, proposed amended language, and current law. As we've done in similar comments, the staff is recommending that these comments be rejected. We're assuming that they're wanting changes to Section 1043B. As we've explained before, we believe this would be outside of the scope of the rulemaking and require additional notice. Our next set of comments comes from John Benuto. Those are on page 41. They indicated in their comments they believe some provisions of the proposed regulations seem ambiguous. And this comes back again to the issues of the status of an ambulatory surgical center. They note that there doesn't seem to be any differentiation between a standard dental office and an ambulatory surgical center. And have requested that SB 501 be modified to reflect the following: that these accredited or Medicare certified ambulatory surgical centers should be exempt from the provisions of the law, that the definition of outpatient should focus solely on dental offices, and that accredited ambulatory surgical centers should be included with acute care facilities in Section 2827, again, of the Business and Professions Code, addressing the use of certified nurse anesthetist. All of these comments have come up before from other commenters. As we've noted prior, we believe that they should be rejected because we believe they do not fall within the scope of the proposed regulatory rule of the process at this moment. And with respect to the suggestion about Section 2827 of the Business and Professions Code, would be outside the board's authority. Our next set of comments comes from Robert Orr, and they start on page 42. And the comment, among other things, is urging the board to consider all stakeholders and believes that there's a lot of negative impact coming from this bill. We are presuming that this commenter is advocating for the board to authorize certified registered nurse anesthetists to perform general anesthesia for pediatric dental patients in an ambulatory surgical center. However, the board's authority to authorize the order or administration of general anesthesia to pediatric patients is limited to dentists and physicians licensed by the Medical Board of California. So again, we have this comment we believe is beyond the authority of the board to address in this specific rulemaking. And again, if we're dealing with changes to Section 1043B of the regulations or to sections of the Business Professions Code, we have to recommend rejecting those comments as either not being related sufficiently to the rulemaking or requiring statutory changes that are beyond the board's authority to address. The next set of comments are from Elizabeth DeBoyer, the Executive Director of the California Ambulatory Surgery Association. They start at the bottom of page 42. The commenter is recommending, there are several comments. The first comment, the commenter is recommending that the board revise the definition for outpatient setting as follows. And I'm quoting from them. For purposes of this article, outpatient setting means a surgical clinic licensed pursuant to paragraph 1 of subdivision B of section 1204 of the Health and Safety Code, an outpatient setting accredited by an accreditation agency as defined in section 1248 of the Health and Safety Code, or an ambulatory surgical center certified to participate in the Medicare program under Title 18 of the Federal Social Security Act, 42 U.S. Code, Section 1395 at sequence. We recommend rejecting this comment. The board's authority for mandating a permit to order or administer anesthesia or sedation is based upon whether the dentist is performing the procedure on an outpatient basis. Outpatient basis, as we are proposing to define, means outpatients. This is in the proposed regulation, Section 1044B. Outpatient basis means outpatient setting is used in Health and Safety Code Sections 1248 and 1248.1, and means all settings where oral conscious sedation is being provided to dental patients, with the exception of a treatment facility which is accredited by the Joint Commission on Healthcare Organizations or licensed by the California Department of Health Services as a general acute care hospital, as defined in Subdivision A of Section 1250 of the Health and Safety Code. So basically, in this particular situation, our review of the relevant statutes indicates that dentists and physicians are still required to comply with the relevant portions of the Dental Practice Act for anesthesia and sedation permits in that outpatient setting. For those particular reasons, we are recommending rejecting the specific comment. The next comment from this from this organization, they're requesting that these outpatient settings, as they defined previously, must be exempt from the regulations and any regulatory oversight by the board. Otherwise, they believe this would constitute an underground regulation by creating barriers to access to care without proper enabling statutes authorizing the board regulatory oversight of these facilities. We are recommending rejecting this comment. The board is not asserting through this rulemaking that we're an authority to regulate ambulatory surgical center settings. We're regulating the dentist's administration of anesthesia and sedation on an outpatient basis, which includes, under existing regulations, administration in settings other than a general acute care hospital. The board's action to implement relevant statutory provisions is not underground, but is connected to existing law and existing regulations. The board does have statutory and regulatory authority over dentists administering or ordering the administration of general anesthesia or deep sedation, moderate sedation, oral conscious sedation for adults, and pediatric minimal sedation to dental patients on an outpatient basis, which would include treatment at ambulatory surgical centers that are considered an outpatient setting by law. This extends to the board's authority to require an on-site inspection and evaluation of the licensee and the facility, equipment, personnel, and procedures that they use to administer or order the administration of anesthesia or sedation as established in Business and Profession Code Section 1646.4A for general anesthesia and deep sedation and 1647.7A for moderate sedation. And in response to a complaint submitted to the board alleging that a dentist or dental assistant has violated any board law or regulation, the board may inspect the books, records, and premises of any California licensed dentist, regardless of practice location, and the licensing documents, records, and premises of any dental assistant. The board is, again, we're recommending that the board reject this comment. And with respect to the comment that's requesting exemption for regulations, that we're assuming, again, that this is going back to the definitions in sections 1043B or 1044A. As we discussed before, we don't believe that these comments are sufficiently related to this rulemaking and would recommend rejecting the comments on those grounds. And the third comment, the commenter recommends repealing the existing definition of outpatient in section 1043B and replacing it with the following. For purposes of this article, For purposes of this article, outpatient means a patient treated in a treatment facility which is not a surgical clinic license pursuant to paragraph 1 of subdivision B of section 1204 of the Health and Safety Code, an outpatient setting accredited by an accreditation agency as defined in section 1248 of the Health and Safety Code, or an ambulatory surgical center certified to participate in the Medicare program under Title 18 of the Federal Social Security Act, 42 U.S. Code, Section 1395 at sequence, or licensed by the California Department of Health Services as a general acute care hospital as defined in Subdivision A of Section 1250 of the Health and Safety Code. As we've done before for similar recommended changes to the definition of outpatient, outpatient setting, or outpatient basis, we recommend rejecting the comment. We don't believe this comment is sufficiently related to the proposed rulemaking. Surgical clinics that are licensed by the California Department of Public Health are specialty clinics defined under Health and Safety Code Section 1204B1 as a clinic that is not part of a hospital and that provides ambulatory surgical care for patients who remain less than 24 hours. The licensing and regulations covering these facilities are less stringent than those for general acute care hospitals, which are obligated to provide more services, to be available 24 hours a day, and to handle inpatient procedures. As a result, the board's existing regulation at Section 1043B recognizes that outpatient basis does not include accredited or licensed general acute care hospitals within the definition of outpatient, because those healthcare facilities provide a lot of different things, including 24-hour inpatient care. And again, the surgical clinics are required to comply with federal certification standards for ambulatory surgical centers found in the Code of Federal Regulations, Title 42, Sections 416.1 through 416.54. It's the board's understanding that these standards are not equivalent to those required for Joint Commission accreditation as a hospital or for licensure as a general acute care hospital by the California Department of Public Health. And arguably, the commenter's proposed amendment appears to conflict with the Health and Safety Code Section 1248B1 definition of an outpatient setting, which states, outpatient setting means any facility, clinic, unlicensed clinic, center, office, or other setting that is not part of a general acute care facility as defined in Section 1250, and where anesthesia, except local anesthesia, peripheral nerve blocks, or both, is used in compliance with the community standard of practice in doses that, when administered, have the probability of placing a patient at risk for loss of the patient's life-preserving protective reflexes. The board's current definition at section of Regulations 1043B incorporates this definition at 1248.1 of the Health and Safety Code, which includes the exemption by law for a general acute care facility, and that acute care facility is defined in Health and Safety Code Section 1250A as a general acute care hospital. We believe the board's current definition, therefore, is consistent with the definitions for outpatient settings and as stipulated in the Health and Safety Code. And on to the next comment. This commenter recommends repealing the existing introductory in Section 1043.3 as follows. So 1043.3 concerns on-site inspections. And the section reads, all offices in which general anesthesia, deep sedation, or moderate sedation is conducted under the terms of this article shall, unless otherwise indicated, meet the standards set forth below. In addition, an office may, in the discretion of the board, be required to undergo an on-site inspection. This next sentence is what the commenter would like to have struck from the definition. For the applicant who administers in both an outpatient setting and at an accredited facility, the on-site must be conducted in an outpatient setting. So we recommend to the board that they reject this comment. It appears to be related to an assertion that the commenters made. The board has no regulatory oversight over premises other than a dental office in which a dentist administers general anesthesia to a patient. As we've described in previous comments, we reject this argument and consider that the proposed requirement that an applicant administers anesthesia in both an outpatient setting and at an accredited facility have their on-site inspection at an outpatient setting focuses the on-site inspection on the area where practice would occur and where there could be an accurate assessment of the standards required for the permit. And this would be consistent with our consumer protection mission, and it adds to the reasons why we would recommend not accepting this particular comment. So I'm now on the next comment for the same commenter. This is at the top of page 48. Commenter recommends deleting the definition proposed by the board for outpatient basis in section 1043.9B relating to pediatric minimal sedation permits and replacing it with the following definition. I quote, outpatient basis as used in section 1647.31 of the code means all settings where pediatric minimal sedation is being provided to dental patients, with the exception of a treatment facility, which is a surgical clinic licensed pursuant to paragraph 1 of subdivision B of section 1204 of the Health and Safety Code, an outpatient setting accredited by an accreditation agency as defined in section 1248 of the Health and Safety Code, or an ambulatory surgical center certified to participate in the Medicare program under Title 18 of the Federal Social Security Act, 42 U.S. Code, Section 1395 at sequence, or licensed by the California Department of Health Services as a general acute care hospital as defined in Subdivision A of Section 1250 of the Health and Safety Code. Staff is going to recommend rejecting this comment. The board has already, we've discussed at length already issues with this particular definition that we would like to emphasize that unless it's a licensed hospital or accredited hospital from the Joint Commission, that we would indicate that it would qualify as an outpatient setting. We believe this remains consistent with other California law. And to make a change in one comment without making changes to other comments would lead to inconsistency, which we would discourage as well. The next comment from the same commenter, they recommend adding the following to the proposed requirements for section 1043.9.1. And this is the current requirements state a licensed dentist who desires to administer or order the administration of pediatric minimal sedation on an outpatient basis is not required to apply to the board for a pediatric minimal sedation permit if they possess another sedation permit from the board. This last phrase is what the commenter would like to add. And in compliance with Business and Professions Code, Section 2725B2. We recommend rejecting this comment. This section, 2725B2, is a provision in the Nursing Practice Act relating to the scope of practice for nursing. As it's not related to the Dental Practice Act, this would be unrelated to the current proposal and beyond the scope of the board's authority. Next comment. The commenter recommends repealing the existing definition of outpatient basis in Section 1044A and replacing it with the following. You'll recognize a lot of this language. Outpatient basis means a dental office where oral conscious sedation is being provided to dental patients, with the exception of a treatment facility, which is a surgical clinic licensed pursuant to paragraph 1 of subdivision B of section 1204 of the Health and Safety Code, an outpatient setting accredited by an accreditation agency as defined in section 1248 of the Health and Safety Code, or an ambulatory surgical center certified to participate in the Medicare program under Title 18 of the Federal Social Security Act, 42 U.S. Code, Section 1395 at sequence, or licensed by the California Department of Health Services as a general acute care hospital as defined in Subdivision A of Section 1250 of the Health and Safety Code. We recommend that the board reject this comment. We've set forth reasons before why we don't believe that the proposed changes would be consistent with current law and the scope of the current proposal. As it would be worth noting that Business and Professions Code Section 1647.19 contains no such limitation on the provision of oral conscious sedation to only dental offices, but similar to other provisions of the Dental Practice Act, requires a permit for sedation on an outpatient basis. Health and Safety Code Section 1248.1, Subsection F, does not limit outpatient settings for dentists to only a dental office. That subsection indicates that compliance with Dental Practice Act requirements relates to any outpatient setting. The legislature has been aware of this requirement since 2005 and has chosen not to act to limit the scope of the required permit to a specific outpatient setting as it has done for other types of permits. The board last considered revisions to this particular section in 2006, and at that time, the board was asked to consider a similar issue. It was suggested that the definition of outpatient basins be amended to include the following: a quote, a treatment facility which or that is accredited as an office-based surgery facility by the Joint Commission on the Accreditation of Healthcare Organizations, close quote. At the time, the board considered that suggested language and agreed with a comment that an evaluation of the Joint Commission's standards may be needed. The board opted not to make the suggested change at that time to maintain consistency with the language for oral conscious sedation for minors. The board also noted that the review of Joint Commission standards would delay implementation of the regulations and impact the ability of patients to seek care. The board did not make the change and requested the staff research the issue and report back to the board. Staff notes that, again, further delaying implementation of the regulations at this time would lead to a lapse in permits for dental general anesthesia and sedation. Formal review of the standards could be done, but staff recommends that such a review not delay implementation of the regulations. And again, for those reasons, we recommend rejecting the comment. Next comment, I'm on the bottom of page 49. The commenter proposes changes to the Business and Professions Code, section 1647.2c, including the requirement that a dentist be physically present in the treatment facility while the patient is sedated when receiving treatment at a surgical clinic. We recommend rejecting this comment. Even the commenter acknowledges in their remarks that the proposed change is the statute and as such would be beyond the scope of the rulemaking process. Our next commenter is Mary McCune from the California Dental Association. Her comments start on page 50. There are several of them. We've summarized as follows. Well, the first comment concerns Form PE1, which is documentation of deep sedation and general anesthesia or moderate sedation cases for pediatric endorsement. The comment suggests that the form is missing the title and fee information. Commenter believes this is intended to be the application form for the pediatric endorsement and that the form is missing a certification of training where the applicant would certify that they have completed the required training under statute. We recommend rejecting this comment for the following reasons. The proposed regulation section 1043.8.1 outlines the requirements for an application to the board for a pediatric endorsement for a general anesthesia permit, and as well as a pediatric endorsement for a moderate sedation permit. Those requirements are going to include, among other things, completing Form PE1, paying the appropriate application fee, submitting a certificate of completion or other evidence showing completion of the training required under statute. And what Form PE1, that is not the form for the endorsement, but it is a form for documenting the necessary cases required for the endorsement. The application is going to consist of Form PE1 and the other things listed in Section 1043.8.1. And the next commenter would like the board to include criteria for the board-approved training in pediatric life support and airway management consistent with Business and Professions Code Section 1601.8. There are no such criteria in the proposed regulations, and the commenter's organization has developed recommendations for such a course that they would consider more appropriate for dental providers. We recommend that the board reject this comment. We don't believe it's necessary to put the specific course requirements for an alternative board-approved training course in regulation. Current laws, Section 1601.8 of the Business Professions Code states that the board may approve a training standard in lieu of PALS certification if a board-approved training standard is an equivalent or higher level of training for pediatric dental anesthesia-related emergencies than PALS certification that includes but is not limited to pediatric life support and airway management. Board cited the American Red Cross, the American Hospital Association, the American Health and Safety Institute as organizations who establish and maintain standards in advanced cardiac life support and pediatric advanced life support. We don't believe that the board can improve on those standards set by these organizations by developing its own criteria for alternative courses. Next comment for this commenter. Consistent with other concerns expressed about the definition of outpatient and outpatient facility, a commenter is suggested revising the definition of outpatient in Section 1043B to include the definition of outpatient setting found in Health and Safety Code Sections 1248 and 1248.1. Again, we recommend rejecting this comment. The proposed changes to existing text and not for something that was noticed in connection with these regulations. This would require a longer notice period and, in our opinion, unnecessarily delay the rulemaking process. We also believe that the definitions of outpatient and outpatient basis are consistent with Health and Safety Code Sections 1248 and 1248.1. Their next comment, the commenter is seeking clarity as to whether dentists may order the administration of deep sedation, general anesthesia within their scope of practice in an outpatient setting as described in Health and Safety Code Section 1248.15 sub 3. The commenter notes that there's legislation under consideration that may allow a certified registered nurse anesthetist to provide such sedation or anesthesia. The board staff is recommending that the board reject this comment. Board is only able to speak to the laws and regulations in effect at the present time, and to the proposed regulations that issue right now. So the Dental Practice Act in Section 1646.1 and 1646.9, enacted as part of SB 501, currently restricts issuing a general anesthesia permit, including deep sedation, to licensed dentists and physicians and surgeons. There's no provision in the Act at this current time to grant an anesthesia permit to a certified nurse anesthetist. The proposed state changes to Section 1043.1 sub B would remove the reference to administration of general anesthesia by a nurse anesthetist to conform the current regulations to the requirements of SB 501. And those requirements have been effective since January 1st of this year. Health and Safety Code Section 1248.15 sub 3 would allow the outpatient setting in its discretion to permit anesthesia service by a certified registered nurse anesthetist. However, a dentist could not, within their scope of practice, order a certified nurse anesthetist to administer deep sedation or general anesthesia. Their next comment, and I'm on the middle of page 52. The commenter suggests that the board define equivalency standards for training in pediatric moderate sedation for inclusion on the form MSP2, which is titled Certification of Moderate Sedation Training. The commenter further suggests that the statutory requirement of 20 cases of moderate sedation in patients under Business Professions Code Section 1647.3 sub D2 should be considered training equivalent to a Commission on Dental Accreditations or CODA accredited pediatric residency. Staff is recommending we reject this comment. The commenter is essentially seeking a statutory change here, which is beyond the scope of the regulatory proceeding. Business and Professions Code Section 1647.3D sets out 4 requirements for a pediatric endorsement for a moderate sedation permit, for which applicants have to confirm all of the following. They would complete a CODA-accredited residency in pediatric dentistry or the equivalent training in pediatric moderate sedation as determined by the board. They would successfully complete at least 20 cases of moderate sedation to patients under 13 years of age. If they're providing sedation to patients under 7 years of age, they must complete 20 cases of moderate sedation for children under 7 in the 24-month period preceding application or renewal, and they must maintain current certification in pediatric advanced life support and area management or other board-approved training in these areas. They must meet all 4 of these requirements. So without a statutory change, we would not be able to substitute or to allow the substitution of those 20 cases demonstration of competency for the CODA-accredited residency in pediatric dentistry or the equivalent training requirement. The next comment is that they believe that Form PE1 is the application for the pediatric endorsement and recommends that Form PE1 be retitled and a certification form added, document training received as specified under Business and Professions Code, Section 1647.2 for moderate sedation of patients under age 13. We recommend rejecting this comment. As stated before, there's no form required in this particular process, but the requirements for application are contained in proposed Section 1043.8.1. The next comment, the commenter believes that this certification of training form is missing from the application for the use of oral conscious sedation for adult patients. They recommend borrowing relevant language from forms OCS-2 and OCS-3 and using that language to replace form OCS-C. The purpose of such a form would be to ensure compliance with BPC Section 1647.20. So we are recommending that the board accept this comment. The currently proposed form OCS-C was intended to cover all requirements for adult conscious sedation and incorporate all existing regulatory or statutory requirements. However, on review of this comment, it was discovered that the criteria for OSC-1 and OSC-4 were not captured on this new proposed form. As a result, we recommend that the board accept this comment and that the text of OSC-C will be modified to request that applicants identify which one of the 4 requirements listed in Business and Professions Code Section 1647.20 they meet, and to include evidence to demonstrate compliance with that requirement. Additionally, Section 1044.4 of the regulations will be retained. It will not be repealed, or that's our recommendation. Applicants seeking to meet the requirement of Business and Professions Code Section 1647.20D, 10 cases of oral conscious sedation satisfactorily performed by the applicant within any 3-year period ending no later than December 31st, 2005, can still use Form OCS-4 to document those cases. All right, I'm moving on to the Section J of the comments. This is a letter from February 15th of 2022 from Valerine, Larry Church, Pankaj Patel, Devin Larson, and Marcus Casper. These are all owners or CEOs of various dental surgery centers. And these comments start on page 53. The commenters are recommending exempting certain facilities from the definition of outpatient in existing Section 1043B of the regulations and outpatient basis in existing Section 1044A, and in the proposed outpatient basis definition contained in Section 1043.9B. And the next comment is that they recommend striking the word offices or office and replacing it with outpatient setting in the regulations, regulatory language for Section 1043.3. which concerns on-site inspections. In terms of the comment concerning exempting certain facilities from the definitions of outpatient, outpatient basis, or outpatient, or outpatient basis, We recommend that the board reject that comment. We've already explained before why we believe such changes would not be consistent with the rulemaking. For their substitution of outpatient setting for office in section 1043.3, we also recommend that the board reject the comment. We believe that the term office is more commonly understood by dentists to include the premises or facility where general anesthesia services are provided, and it's a term used throughout the Dental Practice Act. You can look in sections 1646.1, 1646.9, 1647.16, and that's why we'd recommend not making that change. I'm moving to the next section, K, starts on page 54 in the middle. This is from Gene Vance, who's representing healthcare providers, including several ambulatory surgery centers. And they were requesting that the board amend the proposed regulations to clarify sections 1043B, 1043.3, 1043.9B, and 1044, consistent with the comments that I've just reviewed from the several owners of dental surgery centers. And for those same reasons that I explained in the most recently discussed comments, we recommend that the board not reject the comments from Gene Vance. The next section, also starting on page 54, from Andrew Kugler. Commenter is proposing changes to sections 1043B, 1043.9, and 1044A to exclude the following types of facilities from the definition of outpatient and outpatient setting. Those facilities licensed by the California Department of Public Health as a surgical clinic pursuant to section 1204 sub 1B of the Health and Safety Code, those facilities accredited by an accrediting agency approved by the Medical Board of California pursuant to Chapter 1.3 of Division 2 of the Health and Safety Code, or those certified to participate in the Medicare program as an ambulatory surgical center pursuant to Title 18 of the Federal Social Security Act, 42 U.S. Code Section 1395 at sequence. We are recommending that they reject this comment, as we've discussed before, with several recommendations for changes to Section 1043B, 1043.9, and 1044A. We do not believe the proposed changes to the definition of outpatient or outpatient setting or basis are going to be consistent with the current rulemaking. Additionally, this commenter is also making the requested change of substituting outpatient settings for offices in the language about on-site inspections, and we believe that is also not consistent with the current understanding of the phrase, and we would recommend rejecting that particular comment. So I've gone through all of the written comments that were received. As you know, there was a hearing on February 16th after the request of several parties. This hearing was held by WebEx and took place starting at 1:30 Pacific time on February 16th. 7 individuals offered comments, either on behalf of themselves or particular organizations. In most cases, these people had also provided written comments to the board, and in some cases, individuals who spoke at the hearing provided a copy of their remarks to the board. Several repeated comments. First one being exemption for anesthesia and sedation in outpatient settings that include ambulatory surgery centers. Witnesses Gene Vance, Brian Doherty, Monica Miller, Mary Wilson, Michael Warda, and Ken Pearson each echoed the basic suggestion that I've covered in many written comments that ambulatory surgery centers be exempted for the regulations defining outpatient or outpatient settings. We recommend to the board that they reject these comments. These definitions are in current and proposed regulations we believe to be consistent with the statutory definition of outpatient setting in Health and Safety Code sections 1248 and 1248.1. Bruce Witcher spoke on behalf of the California Dental Association. He basically summarized the written comments provided by the board, which we have already discussed. Bryce Doherty, representing the California Ambulatory Surgery Association, also summarized the written comments provided by his organization. We've reviewed those comments and our recommended changes already. Monica Miller for the California Association of Nurse Anesthetists referenced the comments submitted by her association and agreed with previous comments concerning the status of ambulatory surgery centers. We've addressed those comments before as well. And then finally, Mary Wilson echoed the written comments that she had submitted, suggesting that ambulatory surgery centers be included as acute care facilities under Business and Professions Code, Section 2827. Again, those comments have been previously addressed. So that concludes my summary and overview of the written comments and the comments received at the public hearing for the regulations to implement SB 501. Our request to the board is to consider one of the following options. That if they agree with the staff recommended responses, to move to direct staff to proceed as recommended to accept or reject comments as specified and to provide the responses to the comments as indicated in the meeting materials. If the members have any suggested edits to our recommended responses or disagree with the staff and wish to accept comments or make any other changes, we recommend that they move to direct staff to accept the following comments and make the following edits to the text listing those suggested edits, but otherwise proceed as recommended to accept or reject comments as specified and provide the responses to the comments as indicated in the meeting materials. And Dr. Felsenfeld, I will turn this back over to you to facilitate board member discussion.
Thank you, Mr. Bergman. That was an excellent and long analysis of the things that have been going on. We will now entertain board comments. Are there any board comments on the report as we have heard it? Raise your hand, please, if you wish to speak. I am seeing none at this point. In that case, we would request that a motion be made to either accept, if we're not going to modify, then option number one. We'll need a motion for option number one. Someone's phone is going off, I think. Dr. Chan, is that your phone, or do you want to make a motion?
Make a motion, please.
What would the motion be, sir?
Motion to accept recommendation to adopt.
To adopt. Is that option number one you're telling us about? That
Option number one. That's correct.
Thank you. That's going to be the option to direct staff to proceed as recommended to accept or reject comments as specified and provide the responses to the comments as indicated in the meeting materials. Is there a second? I see Dr. Yu. Dr. Yu?
Second.
Dr. Yu seconds it. All right. Is there any further board discussion on the motion? Seeing none, we're ready for public comment. Moderator, would you please facilitate public comment?
Open the Q&A panel. If you'd like to comment on the motion before you, please click on the Q&A icon on your screen. Type comment or I would like to make a comment into the text box and submit that to the host. If you're a call-in user, you may raise your hand by dialing *3. Our first comment comes from Beth LeBoyer. Beth, I've sent the request to unmute your microphone. As a reminder, you will have 2 minutes.
Good afternoon. I'm Beth LeBoyer, the Executive Director of the California Ambulatory Surgery Association, also known as CASA. We are the statewide association of ambulatory surgery centers, and our over 400 members champion the advancement of ambulatory surgery technology and promote the safe, efficient, and cost-effective utilization of care in the outpatient setting instead of other costly alternatives. CASA provided written comments and testified to these comments during the Dental Board's February 16th public hearing on these proposed regulations. CASA strongly believes that these proposed regulations miss the mark on the definition of outpatient and outpatient setting. We've identified 5 specific areas of the regulations that need to be amended in order to comport with existing law. We also recommend one section of the B&P code that also needs to be amended in order to comport with existing law. Currently, there are approximately 64 ASCs in California providing some form of dental services with a small amount of these facilities exclusively providing dental procedures. Perhaps most importantly, the regulations as presented create a significant access to care issue, particularly for the children served by Medi-Cal. Therefore, we strongly believe that the definitions and exemptions in these regulations need to be specific to an ASC that is accredited, Medicare certified, and/or state licensed. Thank you.
Thank you. Our next comment comes from Jean Vance. Jean, I've sent the request to unmute your microphone.
I'm Jean Vance, healthcare attorney with the law firm of Weintraub Tobin. I've been practicing health law since the mid-1990s, representing institutional providers such as hospitals and surgery centers. The purpose of this law was to increase the standards for providing anesthesia in dental offices, which were not regulated settings. There's nothing unique about dental anesthesia that makes it more inherently dangerous than anesthesia provided in other settings. I submitted comments to the dental board hearing that would have clarified that these general anesthesia permit requirements would not apply in settings that are highly regulated outside of dental offices merely because the patients have an issue in their mouth. Staff at for the bill recommended clarifying the definition of outpatient basis to provide that it does not include the services of a general acute care hospital, even if the services were provided in an outpatient department of a general acute care hospital on outpatients, and the board adopted this regulation. We think that this was adopted in error. The original statute did not contain any such exception or clarification, but the dental board here appropriately determined that it was within its discretion to define what outpatient basis means. We believe that discretion needs to be exercised to further clarify that these rules do not apply to ambulatory surgery centers. These ambulatory surgery centers that are Medicare certified and licensed. While there was a comment about ambulatory surgery centers licensing standards being less than a general acute care hospital, that is true from a licensing standpoint, but that ignores the fact that they are subject to Medicare certification and accreditation standards, which are very extensive and is the reason your packages for this meeting are so very lengthy, was the Medicare standards that apply to these surgery centers. In addition, the regulation that was adopted.
Time has expired.
Okay.
Our next comment comes from Dr. Bruce Witcher. Dr. Witcher, I've sent the request to unmute your microphone.
Thank you for that exhaustive presentation covering all the rationale that the board staff very painstakingly worked out. Although ASCs, I think, do provide a very high level of care, we have to recognize that what is before us is really a regulatory legal issue, and that what many of our commenters have requested is that we try to amend statute through regulation, which is really not something that is allowed and would cause our comments to be rejected. I would urge the board to go ahead and adopt the staff recommendation and move this forward so that the board can begin issuing new permits. Because if anything will affect access to care, it's the inability of the board to issue new sedation and anesthesia permits, which is hinging on this particular motion. That concludes my comment. Thank you very much.
Thank you. Our next comment comes from Michael Warda. Michael, I've sent the request to unmute your microphone. We can.
Good. I want to thank staff and the legal counsel for the analysis provided. I think primarily the issue here that we have is that under the Business and Professions Code, the use of a nurse anesthetist can operate and be directed by a physician, dentist, or podiatrist in a hospital. The ambulatory surgical centers have the same procedures in place to protect patients with respect to the anesthesia procedure. So what I would ask is if the board wants to proceed with the regulations today, can you please direct staff and yourselves to address this issue and help us get and modify state law? Because I think that the board has been tasked by the Office of Oral Health to implement rules, and part of that is to assess the dental needs by race, ethnicity, geography, income, all kinds of levels. And these kids that are being treated at the ASCs need access to this care. And if a nurse anesthetist by statute can work in a hospital under the direction of a doctor or dentist that doesn't carry an anesthesia permit, a dentist shouldn't be treated differently. I mean, he's a doctor. He should be treated as a doctor. And that's what, and this board should protect dentists and say, we want you to have the ability to use anesthesia the same way you would have if you're in a hospital, provided that you're in a certified facility. So I urge the board to work with this group, work with the communities to immediately get this, to immediately get this issue resolved. I think it's critical. It's going to head in that direction anyway, and I think it's super important for this board to be on board. Thank you very much.
Thank you. And our next comment comes from our calling user. I've sent the request to unmute your microphone.
Hi, this is Maura Tuso. I appreciate how in-depth this entire presentation was about using general anesthesia in dental offices and the dental board policing or ensuring that the public safety is preserved. I'm super nervous. I have so much anxiety. I'm so afraid of all of you there at the dental board. So I'm speaking because I'm trying to ask, again, I don't have a home computer. I haven't had one since 2012, how I can get statements or concerns addressed officially at a dental board meeting. Because when I asked the question on November 18th, 2021, how and when can I apply for my license back? Because even today, I'm speaking to Borrego's fraud attorneys about your licensees, Timothy Martinez, Hassam El-Dari, Nithya Venugopal, Elias Kutro.
Dr. Tiso, once again,
involved in fraud.
Can she be muted, please? She's once again going off topic.
And with that, we have no further requests for comment. Would you like me to close the panel?
Yes, please.
It is closed.
I was going to make one comment in general. Ms. Shields, did you have anything you'd like to add to this before we take the vote?
Sure. I think I just want to make sure that we address the largest comment concern that has been brought forward in this rulemaking, which is the definition of outpatient or outpatient basis. I think that the issue here is a statutory authority issue. The board, if you look in your materials, and you've been provided a copy of the first iteration of the board's authority in 1979 for general anesthesia permits, and that outpatient basis authority existed then and has continued to exist for the next 40 plus years. So that authority has been there for a long time. And the problem here is that the board can adopt rules related to the profession, but they have to be grounded in reality. And the reality here is that the facilities that are definition are providing services on an outpatient basis. If you look at the definition for what an outpatient is, just in the dictionary, is a patient who receives medical treatment without being admitted to a hospital. So you have the ordinary, commonly understood meaning of outpatient, which the board is following in its current definition. And you have the health and safety code provisions that are cross-referenced currently within the board's regulations that are consistent with the Health and Safety Code's definition of an outpatient setting. So I don't think the board can make the legal argument to the Office of Administrative Law that it has the power to carve out exceptions to different outpatient settings and cherry pick which dentists have to comply in which setting. That is something that would be something before the legislature and something that the board would want to discuss on a policy basis. So I don't believe that this rulemaking is the appropriate place for that discussion. So that's the only thing I would add. If the board members have any questions for me, I'd be happy to answer them.
I don't see any hands going up. Let me just finish with one comment. This is a very sensitive area. We've had a lot of discussions, and there's a lot of people who have a lot of thoughts on this. First of all, we are needing to move on to protect those of us who are providing anesthesia services. And if this gets bogged down more, we're going to have fewer providers doing that. Number one. Number two, we are going to discuss at a future board meeting the role of nurse anesthetists. We've already begun discussions with them, and also look at the ambulatory surgical centers in the future. That's going to be on an agenda item. So we will be looking at this philosophically and asking for additional information. Having said that, the board secretary, would you like to call the roll and record the votes for this agenda item?
Yes, this is Dr. Sonia Molina in agenda item number 4. Would you like me to read the option 1 or just?
Please read option 1 because that is what everyone is voting on.
Okay. So if the members agree,
No.
then staff is
direct
staff to proceed as recommended to accept or reject comments as specified and provide the response to the comments as indicated in the meeting materials. Chan.
Chan, aye.
Chan, aye. Fessenfeld.
Felsenfeld, aye.
Fessenfeld, aye. Larin. Larin, aye. McKenzie.
McKenzie, yes.
McKenzie, aye. Medina. Medina, aye. Molina. Molina, aye. Montel.
Montel, aye.
Montel, aye. Morrow. Morrow, aye. Olagi.
Olagi, aye.
Olagi, aye. Pacheco. Pacheco, aye. You.
UI.
You, aye. Motion passes.
Terry. We now go to agenda item number 5, discussion and possible action to consider the adoption of the proposed amendments to California Code of Regulations, Title 16, Sections 1021, 1043, 1043.1, 1043.2, 1043.3, 1043.4, 1043.5, 1043.6, 1043.7, 1043.8, 1044, 1044.1, 1044.2, 1044.3, 1044.5, 1070.8, 1017.1, 1043.8.1, 1043.9, 1043.9.1, 1043.9.2, and 1044.4 relating to SB 501, anesthesia and sedation rulemaking. Mr. Bruggeman, you're up again, if you will.
Hello. So now we're going to review the proposed modified text. And I want to emphasize that we're talking about modifications being made to the proposed regulations. As in your meeting materials, you'll see the full proposed text of the regulations starting on page 351. Anything that are modifications to the originally proposed regulatory language, they're going to be shown in double underline for new text, double strike through for deleted text, and they will be in yellow highlight. And I just want to distinguish that from the other proposed regulatory changes that were already noticed, and we're not making any suggestions to the material that is not highlighted. Just want to be clear about that before I review the recommendations for modified text. I'm going to start on page 23 of the meeting materials to summarize are proposed modifications to the regulatory text. The first change would be to make non-substantial clarifying changes to the introduction to the proposal, including adding the word "and," adding titles for the existing Chapter 4 and article title references to the introduction to the regulatory proposal so that the regulated community has notice of where Section 1017.1 is located. We'd also strike the reference in the introduction to the proposed repeal of Section 1044.4 of Article 5.5 of Chapter 2, which, as we'll get to in just a moment, the board has approved the recommendation to retain that section instead of repealing it. Proposed Section 1043.8.1 would strike and renumber subsection C, and so the relevant cross references in the various subsections would be need to renumbered to match Section 1043.8.1. So Business and Professions Codes Sections 1646.2 and 1647.3 contain a 24-month currency of knowledge requirement that unfortunately was not reflected in the pediatric endorsement renewal requirements for moderate sedation permit holders in proposed regulation section 1017.1b, subsections 1 and 2. In addition, the word "under" was inadvertently left out of the originally proposed regulatory language posted and mailed to the public in subsection B3. So we'd want to make the following changes. In subsection 1017.1b, we would add to the end of it, as a condition of renewal, each dentist licensee who holds a moderate sedation permit with a pediatric endorsement shall confirm to the board in writing the following as part of the permit renewal requirements in section 1043.8 application. And in the subparagraphs 1 and 2, we're adding language for that 24-month currency of knowledge requirement. In subsection 3, we're going to add the word "under" after the phrase "under 7 years of age," only under the direct supervision of a permit holder. Next, we would amend Section 1021 to add references to fees for physicians and a non-substantial change to correct the introductory title to properly reflect the types of licensees covered in the following fee section, or schedule. Currently, Section 1021 refers to fees for dentist examination and licensure by the board. And since this section also includes fees for permits that can be held by physicians and other licensees, the introductory text needs to be revised to accurately reflect the existing and proposed fees in that section. So again, we would add at the end of the introductory portion of the section, "and for other licensee, registrant, or application types specified below." And when we get to the portion of that section concerning general anesthesia and moderate sedation permits and pediatric endorsement for general anesthesia, we would add in parentheses for each portion there for dentist and physician licensees. I'm now at the beginning of page 25 in the meeting materials. The next change is to make non-substantial changes in response to public comments about updating outdated references. These would be the references to the Joint Commission and to the California Department of Health Services. Those would be updated to reflect the current usage, which is the Joint Commission as well as the Department of Public Health. And those would be the sections 1043B, 1043.9B, and 1044A. Additionally, in each section, there's a phrase, "a patient treated in a treatment facility which," and the suggested change is to strike "which" and replace it with "that," and that's for grammatical clarity. And again, each of these changes will be made to sections 1043B, 1043.9B, and 1044A. Next proposed change is to amend Section 1043.3 to clarify a reference to an on-site inspection. In the first paragraph, the third sentence, the text currently reads, the on-site must be conducted in an outpatient setting. We're recommending adding the word inspection after on-site to provide additional clarity. Now on top of page 26, we recommend amending section 1043.6B2 to include the language that the applicant given conditional approval will be considered to have passed the evaluation if they have corrected deficiencies within the 15-day period following receipt of notice of those deficiencies. And that would be inserted nearly at the end of the sentence, or at the end of this section. The next suggested change is to amend section 1043.6C to replace the word retested in the last sentence with the word reevaluated. This section concerns evaluations rather than tests, and so this would be done to provide more consistent language. And again, this language is nearly at the end of this section 1043.6C. Recommend amending section 1043.8.1B to renumber sections 6 and 7. It was misnumbered. There's currently no subsection 5, so we would renumber sections 6 and 7 to 5 and 6, respectively. We recommend deleting section 1043.8.1C as the text in this section, which concerns submitting case documentation for pediatric endorsements, is already addressed in section 1043.8.1B3 and on the PE1 form. Recommend amending in the introductory text of section 1043.9.2 to include equipment standards for maintenance, testing, and inspection, as well as the appropriate size of equipment, medication, and resuscitation capabilities for a pediatric population. This would be consistent with the language on the PMSP1 form and the language for equipment standards for other anesthesia and sedation types. The specific suggested text would be, all equipment should be maintained, tested, and inspected according to the manufacturer's specifications in an office where minimal sedation services are to be provided to pediatric patients. The required equipment, medication, and resuscitative capabilities shall be appropriately sized for use on a pediatric population. Next recommended change is to amend section 1043.9.2 to delete the requirement that equipment must be maintained in good operating condition. Because other proposed changes in for modified text would add a requirement for maintaining equipment, maintaining testing, and inspecting equipment according to manufacturer's specifications, that having this language about maintaining in good operating condition would be redundant. Next suggested change is to rescind the repeal of section 1044.4, documentation of 10 cases, and to remove references to that repeal in the modified text. It was determined on review that the board lacks statutory authority to repeal section 1044.4, which implements Business and Professions Code section 1647.20. Form OCS-4, the form that the board currently uses to implement section 1647.20, would also not be repealed. Yes, this is an outdated pathway. It's typically not used, but we would still require, it's still a statutory change, and it's not something we can do through a rulemaking proceeding. The next suggested change, amend section 1044.5B to delete the requirement, and this is much like a previous suggested change, to delete a requirement that equipment must be maintained in good operating condition. Other proposed changes are covering equipment standards in proper form. And now we're talking about modifications to forms. This is at the bottom of page 27. We recommend amending the GAP1 form introductory text to update language referring to which state agencies may share taxpayer information with the board and under what circumstances an unpaid tax obligation may result in a denied application or suspended permit. These changes would clarify the relevant section of the Business and Professions Code that applies and reflect recent changes to that section. The text would be modified to state, under Business and Professions Code sections 31 and 494.5, the California Department of Tax and Fee Administration, and not the State Board of Equalization, and the Franchise Tax Board may share taxpayer information with the board. And later on in that same paragraph, it indicates this application may be denied or your permit may be suspended if you have a state tax obligation and the state tax obligation is not paid and your name appears on the State Board of Equalization, the CDTFA, or the Franchise Tax Board certified list of top 500 tax delinquencies. Next change to the GAP1 form would be to add a "to" before pediatric patients in the text section that's labeled Facilities and Equipment Requirements. This would be for the purposes of clarity. The next change would be to amend the GAP1 form to remove the phrase "as medically required" from the end of question 23 on the form. This would be done for consistency to make the question more consistent with the language of section 1043.3B1. Next suggested change is to amend the GAP1 form question 26 to move the "or" that's currently after the phrase "if the patient is a minor" to before that same phrase. This will provide clarity as to whom may provide consent on behalf of the patient and under what circumstances they may do so. Next suggested change would be to amend the GAP1 form section at the very end of the form that reproduces section 1043.8.1 for the convenience of applicants. And the idea here is that just to be consistent with the other changes we are proposing for section 1043.8.1. The next change switches to the MSP1 form. It would amend the language of section 1043.8.1, subs A, B, and C that are on the MSP1 form to reflect the changes made to that language in regulation. And it would also delete an inadvertent insertion of the text "advanced cardiac life support" in parentheses ACLS and in subsection A4. And again, this would be to make the regulatory language on the form consistent with the modified text of the regulations. The next suggested change is to amend the MSP1 form to make the same changes concerning what state agencies may share taxpayer information with the board and under what circumstances an unpaid obligation may result in a denied application or suspended permit. The next suggested change would be to add a "to" before pediatric patients on the MSP1 form in the text section labeled Facilities and Equipment Requirements. We're doing something similar on the GAP form. The next suggested change would be to amend the MSP form question 26, like we did for the GAP form, to move the "or" after the phrase "if the patient is a minor" to before that same phrase. On number 20, next the suggested change on the MSP2 form. In the first paragraph of question 4, we would want to correct the spelling of administration. It is missing the second I. Next change would be to amend the PE1 form introduction to clarify the pediatric permit renewal requirements for general anesthesia permit holders with a pediatric endorsement and moderate sedation permit holders with a pediatric endorsement, consistent with the requirements of section 1017.1 of the regulations. And this would change an error cross-referencing section 1043.8.1. The specific text of the change would add the phrase in parentheses "for both general anesthesia and moderate sedation permits" following this phrase. This document shall be completed in its entirety as part of the initial application for a pediatric endorsement in parentheses for both general anesthesia and moderate sedation permits. I'm now on the top of page 30. The next suggested change is to amend the PE1 form to modify question 4 in order to better ensure applicants for pediatric endorsements of moderate sedation permits provide the required information. It's going to add language to emphasize the need to complete the following section of the form and refer them to the notice statement on the form for additional requirements. Text would be modified to state, so for applicants for a moderate sedation permit only, this is the new text, please complete this section. In parentheses, it says, see requirements in the notice statement above for providing moderate sedation to children under 7 years of age. Next suggested change would be to amend the PE1 form to change the language requesting specific information about the anesthesia or moderate sedation cases being documented to comply with the requirements for the pediatric endorsement. This would make a new question 5 and be revised to emphasize that all applicants need to complete the question. So the text would be modified and it would start with a new phrase, for all applicants, please provide all the following information and the new language on this form or in attachments to this form by case number. The next suggested change would be to amend the PE1 form to renumber the last question and references to other questions on the form. Because we've added a new question 5, existing question 5 has to be renumbered to 6. References to questions 4A and 5A will need to be renumbered 5A and 6A. The next suggested change would be to add the word immediately to the introductory sentence on page 3 of this form to more accurately describe the currency of knowledge requirements set forth in Business and Profession Code section 1646.2 and 1647.3. The text currently reads, applicants must provide the following for each case occurring within 24 months preceding application for the pediatric endorsement. The immediately would go before preceding, so the phrase would now read, within 24 months immediately preceding application. Next suggested change is to amend the PMSP1 form introductory text to update language referring, as we've done with 2 other forms so far, what state agencies may share taxpayer information with the board, and under what circumstances an unpaid tax obligation may result in a denied application or a suspended permit. And the next change would be, as we've done with some other forms, to amend the PMSP1 form text section labeled facilities and equipment requirements to replace, this is actually a new change. Amend the PMSP1 form text section labeled facilities and equipment requirements to replace the word anesthesia with the phrase minimal sedation and to add a to before pediatric patients for the purposes of clarity. The next suggested change would be to amend the PMSP1 form in question 14 to replace the word factility with the word facility. Next suggested change would be to amend the PMSP2 form in question 4 to correct the spelling of administration in the first paragraph. It is missing the second I. In that same question, the period following the phrase clinical case should be removed for clarity. And a clinical case can be found in the checkbox that reads at least 24 hours of pediatric minimal sedation instruction in addition to 1 clinical case. Shouldn't be a period there. And training in pediatric monitoring, airway management, and resuscitation and patient rescue from moderate sedation or. The next suggested change, rescind the repeal of Form OSC4. This form is incorporated by reference in Section 1044.4, and the modified text would no longer repeal this section, so the form itself would not be repealed. Next suggested change is to amend the OSCC form introductory text to update language, again referring to which state agencies may share taxpayer information with the board and under what circumstances an unpaid tax obligation may result in a denied application or suspended permit. These changes would be consistent with what are recommended for 3 other forms. The next suggested change, I'm on the top of page 32, amend the OCSC form to add a question 10 on how applicants are qualifying for the permit under Business and Professions Code section 1647.20 in response to comments from the California Dental Association. So this section describes the 4 requirements under section 1647.20, and the applicant would need to indicate which method they would qualify for the sedation certificate for adults. And they would need to attach the appropriate documentation as set forth within these requirements. The next suggested change, amend the OCSC form to renumber the questions following this question 10. So the current questions that are numbered 10 through 25 would then become questions 11 through 26. The next suggested change is to amend the OCSC form in question 21 to remove the reference to the maintenance of ancillary equipment. This language change is consistent with other changes we're recommending concerning on-site inspection. The text in this case would be modified to state this new question 21, do you have ancillary equipment? And it would strike this phrase, and is all ancillary equipment at the facility maintained in good operating condition? The rest of the question would remain. For the purposes of this question, ancillary equipment must include all of the following, etc. So additionally, to make sure that all arguments behind our choices and the documents relied upon in consideration of these proposed amendments are included as part of the rulemaking file, staff is recommending adding the following materials to the rulemaking file, which must be noticed for public comment as part of any proposed modifications to text. These would be form application for oral conscious sedation for minor certificate. This is OCS 1, revision date January 2005. Form would show that it is being repealed. Form application for adult oral conscious sedation certificate, OCS 3, revision March 2007, also showing that it is repealed. Form OCS 4, revision March 2007, documentation of oral conscious sedation cases, an addendum to the initial statement of reasons, relevant citations from case law statutes, Chapter 886 of statutes of 1979, pages 3071 to 3073, and the Joint Commission 70-year historical timeline published by the Joint Commission reflecting their name change. So at this point, I have reviewed the suggested changes, the modified text that the board staff is recommending. So I open it up to the questions, Dr. Felsenfeld, and other board discussion.
Thank you, Mr. Bergman, once again. Is there any board discussion about any of the changes in this document? I am seeing none. We're going to need a motion, and someone's going to have to read the motion to us. Is there a motion to go with option 1, but we have to read that into the record somewhere? I'm seeing nobody even moving that.
This is Steve Chan. I'll move to adopt the proposed amendments.
Okay, sir, thank you. We will read it to the record. I think Dr. Molina, get ready because you're going to read it as you read the motion. But all right, thank you, Dr. Chan. Do we have a second? And I see Ms. Montel. Dr. Montel, excuse me, Dr. Montel.
I second the motion.
Thank you very much, Dr. Montel. All right, Chan is the mover and Montel is the seconder for option number 1. Is there any further board member discussion? Dr. Loreen, did you want to comment on something or no? Yes, no? I see your hand going up and down.
I was going to second that, but I don't think you're seeing my hand when I put my hand up. I put it up several times before.
I see it now. I see it now. We're good. All right, very good. In that case, is there any public discussion? Moderator, please facilitate the public discussion.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on this item, please click on the Q&A icon on your screen, type comment into the text field, and submit that to our panelists. Our calling users may raise their hand by dialing *3. And as a reminder, this is for comments on the motion before you on the regulatory package. Any comments not related to the current agenda item, commenters will be muted. We have a comment from our calling user. I have sent a request to unmute your microphone. As a reminder, you will have 2 minutes.
please stop muting me. This is more to. Can
Hello?
you hear me?
We can hear you now.
So I'm asking you to please don't mute me. I've asked numerous times in numerous ways, how do I get my concerns formally addressed at a meeting? Because when I did on November.
If you're not going to comment on this particular part of our regulatory package, you are out of order at this point. So please, we are aware of your comments. Ms. Wallace is aware of it, and she will be in touch with you. Please mute her at this point. Unless you have something to say about this regulatory package, do you? I'm guessing no. All right, continue, moderator.
All right, not seeing any other requests for comment. Would you like me to close the panel?
Please do. Please
It
do.
is
All right.
closed.
We have before you Dr. Molina. You're going to have to read this. I apologize to you, but Dr. Molina, would you be kind enough to read the motion, and then we will take the vote.
Okay, this is Dr. Molina. In the motion, option 1 says that the proposed that approve the proposed modified text and documents added to the rulemaking file, and direct staff to take all steps necessary to complete the rulemaking process, including sending out the modified text with these changes and notice of the addition of documents added to the rulemaking file for an additional 15-day comment period. If after the 15-day public comment period, no adverse comment are received, authorize the executive officer to make any non-substantive changes to the proposed regulation and adopt the proposed regulations, including the decision not to repeal section 1044.4 as described in the modified text notice for 16 CCR, sections 1017.1, 1021, 1043, 1043.1, 1043.2, 1043.3, 1043.4, 1043.5, 1043.6, 1043.7, 1043.8, 1043.81, 1044, 1044.1, 1044.2, 1044.3, 1044.4, 1044.5, 1070.8, 1043.9, 1043.91, and 1043.92. Now I will call the roll. Chan.
Chan, aye.
Chan, aye. Fessenfeld.
Felsenfeld, aye.
Fessenfeld, aye. Larin.
Larin, aye.
Larin, aye. Mackenzie. Mackenzie, aye. Medina. Medina, aye. Molina, aye. Montel.
Montel, aye.
Montel, aye. Morrow. Dr. Morrow. Olagi. Olagi, aye. Pacheco.
Pacheco, aye.
Pacheco, aye. And you. You, aye. Motion passes.
Thank you, Dr. Molina. It is now 2:13. We're going to take we only have one more regulatory package to go today. Let's take a 15 or 17-minute break and come back at 2:30. We'll consider that, and that will end our business. 17-minute break till 2:30. Moderator, is everybody back?
I believe so. Let me resume the recording.
This meeting is being recorded.
Welcome back, everyone. We have one more item of business to complete, and this is an emergency rulemaking packet. I'm going to call on Mr. Brueggemann, who's been very busy, to present this item on the discussion and possible action to initiate an emergency rulemaking, adopt regulations on a finding of emergency, and initiate a regular rulemaking to adopt California Code of Regulations, Title 16, Section 1066, relating to dentists initiating and administering vaccines. Mr. Brueggemann.
Hello. As the slide indicates, this is an emergency rulemaking, which is a somewhat different proceeding than a regular rulemaking. And the resulting regulations would be temporary in nature. I'm going to defer to our regulatory counsel to give some more specifics about the differences between an emergency rulemaking and a regular rulemaking. So, Christy, if you could educate our members on that for us, please.
Okay, so can everyone hear me?
Yes, we can.
Great. So emergency regulations are a process for adopting regulations on a temporary basis in response to a situation that calls for immediate action to avoid serious harm to the public peace, health, safety, or general welfare, or if a statute deems a situation to be an emergency, you can establish that emergency. And in this case, we were given the declaration of emergency status in BPC, Business and Professions Code section 1625.6, which is a gift from the legislature. So we don't have to actually prove that our emergency proposal is an emergency. We've gotten that green light, so to speak, from the legislature. Because emergency regulations are intended to avoid serious harm and require immediate action, the process for emergency rulemaking is substantially abbreviated compared to the regular rulemaking process that we just discussed in Agenda Item 4. At least 5 working days before submitting an order to OAL, the board would have to send a notice of the proposed emergency action to every person who's filed a request for notice of the action. That notice has to include the specific language, which is the order of adoption in your packet, and the finding of emergency, which is also in your packet. OAL has 10 calendar days within which to review an emergency regulation filed prior to notice and hearing. OAL must disapprove a regulation if it determines the situation addressed by the regulations is not an emergency. The regulation does not meet one of the 6 standards we discussed previously, or the agencies fail to comply with the rulemaking requirements for an emergency. Once you have filed an emergency order, you must complete the entire notice and hearing process required for regular rulemakings within, in this case, 240 days from the date your order was approved by the Office of Administrative Law. Again, we got an extra extension in statute. Usually it's 180 days, but in our case, the board has 240 days to complete the rulemaking to make it permanent. You have to adopt the emergency regulation within this time frame, or the regulation's automatically repealed. You can request 2 emergency readoptions for a period not to exceed 90 days each, but only if you've made substantial progress toward completing the regular rulemaking process, which includes the hearing I just mentioned within that process. But for the initial approval of the text, it's a 10-day period. So in summary, the notice of intent is filed and posted on your website. 5 days later, the board would file the notice, order of adoption, and the finding of emergency with the Office of Administrative Law. The public would get on these regulation proposals, and then OAL has 10 days, calendar days, to review and decide whether to approve the action. So with that, I don't know if the board members have any further questions about the process, but that's a quick overview.
Thank you, Ms. Shields. Are there questions about the process before we let Mr. Brueggemann go? All right, sir, you're up. Mr. Brueggemann.
Thank you. So these emergency regulations are to help implement Assembly Bill AB 526, and that bill was signed into law on October 8th of 2021. It amended the Dental Practice Act to permit dentists to prescribe and administer influenza and COVID-19 vaccinations approved or authorized by the Federal Food and Drug Administration to patients 3 years of age and older on a permanent basis. Dentists who administer these vaccines would have to complete a vaccination training program every other year offered by the CDC or a provider approved by the board. They would also have to comply with all state and federal record-keeping requirements, including documentation for the patient's primary care provider and entering the vaccination information in the appropriate immunization registry designated by the immunization branch of the California Department of Public Health. So dentists already have this authority, but we don't have specifics on the length of the required training program or on how dentists are to provide immunization information to the patient's primary care providers or to the state immunization registry. So that's what these emergency regulations would do. And so we've got some developed language here. This would be Title 16 of California Code of Regulations, Section 1066, to address the training, continuing education, notification, reporting, and documentation requirements for dentists to comply with the law. And if you would like to take a look at the language in its entirety, that's going to start on page 442 of your meeting materials. I'm simply going to summarize each of the major sections of the proposed regulations. Subsection A, dentists seeking to prescribe and administer vaccinations would have to comply with all portions of this section of regulations. Failure to do so would constitute unprofessional conduct. Subsection B, dentists are going to have to retain documentation of their immunization training in order to comply with the law, that they have to take to comply with the law. They would have to maintain it on the premises and keep it consistent with existing regulations at Section 1017 for documenting their continuing education courses. Subsection C, dentists would have to complete 1 hour of vaccination training every 2 years to comply with the law. The training must include a vaccine administration, prevention and management of adverse reactions, and maintenance of vaccine records from an approved provider. Such a provider could be the Centers for Disease Control Prevention or a continuing education provider registered and approved by the board pursuant to Section 1016 of regulations. Subsection D, dentists would have to notify the patient's primary care provider or enter the vaccination information in a record system that's accessible by the patient's primary care provider within 14 days of administering the vaccination. If a patient doesn't have a primary care provider or is unable to provide contact information for that provider, the dentist shall advise the patient to consult an appropriate healthcare provider of the patient's choice. Subsection E, dentists must submit the required information with the Department of Public Health, which is currently done through the CARE or California Immunization Registry, within 14 days of administration of the influenza vaccine or within 24 hours of administration of a COVID-19 vaccine. Dentists must complete the required registration process for reporting this information in the registry via the online care portal designated at the California Department of Public Health website. They must notify the patient or their guardian of the dentist information sharing requirements under the law and of the rights of the patient and or the patient's guardian with respect to information that's shared with the Department of Public Health. Subsection F, for each vaccine administered, the dentist has to provide a patient with a vaccine administration record, and that record must also be maintained in an automated data processing or manual record system that would allow that information required by federal law to be available during normal operating hours. And such a record has to be maintained for at least 3 years from the date of the administration of the vaccine to the patient. Typically, this requirement would be met by providing a COVID-19 vaccination record card if they're administering a COVID-19 vaccine, or a form like the California Department of Public Health immunization record and history form if they're providing an influenza vaccine. Subsection G, the proposal would add definitions for items used in this section: patient vaccine administration record, vaccine information statement, and the COVID-19 vaccine emergency use authorization fact sheet, or EUA fact sheet. And again, you can find those specific definitions in the full text of the law on page 443. And we have the other documentation, the finding of emergency, which summarizes much of what I've already covered in terms of the specifics for the law, the requirements for meeting the emergency, as was previously stated. Under a provision of statute, such regulations would be deemed as meeting an emergency. So we fit that criteria there. And the idea here is to make specific these requirements for training, continuing education, notification to the patient's primary care provider, and reporting and record-keeping requirements for dentists, more specific than what's currently in the law. So at this point, I would like to turn it back over to Dr. Felsenfeld for any questions from the board.
Thank you. Thank you, Mr. Brueggemann. I'm going to recommend that if and when we make a motion, that both of these two options is really part of one motion from a parliamentary standpoint. The second one hinges on the first, and it wouldn't be appropriate to make this without the first one being there. So let's see if there are any comments from the board on either parts of these two paragraphs. Any board comments? Dr. Loreen.
Yes, I'm here. Thank you. I have a question. During the pandemic, there were many dentists that volunteered at facilities to place the vaccination, the COVID vaccination. This looks like it's more for a dentist who wants to place vaccinations in his office. I'm just concerned that people that are going to want to volunteer in the future may think that they also have to, apply all these regulations or policies when they're also volunteering. So I just want to see where that is mentioned. I know I read it in the July, where is it? I had it right here. I read it in the hearing date, July 12, 2021, that it says that to independently prescribe and administer COVID vaccines, but I don't see it in the rest of the documentation. So can you please explain how this would apply to dentists that are volunteering at another facility that is not their own?
Council, does council have any comment on that by any chance?
Yes, this is Christy Shields. So the statute actually says, in addition to the actions authorized under section 1625, a dentist may independently prescribe and administer influenza and COVID-19 vaccines approved or authorized by the U.S. Food and Drug Administration. So it does actually say that at the beginning of this authorizing statute.
Yes, that's what I read. Is that going to be insufficient? Do you think that's going to be sufficient wording?
Well, it says, I mean, I don't know what else independently prescribed could mean. I'm not sure. I mean, I don't want to, presume that they meant something else. I mean, independent means there's no other. It's not
in their own office
administration.
Or,
this is
I don't know.
Just the dentist.
I mean, if it's okay with everyone, that's fine. But I just worried a little bit that the volunteering dentists are acting, independently because they're not hired and they're volunteers, and they may think that this also applies to them. I don't know if that's enough, but if it's okay with everyone, that's fine with me too.
I mean, it does. Yeah, I mean, it does apply to them wherever they practice. So, I mean, it's independent in the sense that they're doing it pursuant to their current scope of practice. In their scope of practice, they have to maintain all of these requirements and still meet all these requirements. I don't know that if they work in a different setting, that it would exempt them from these requirements to have the training and documentation. That's not what was intended by this particular statute, in my view. Board counsel has a different opinion.
The training is fine. It's just where you have to record everything, because the volunteer entity where you're placing these vaccines are doing that for you. So
right, and so as long as it's recorded somewhere, it's compliant, because remember, these requirements are merely reflective of existing state and federal law. So the dentists already have to comply with the California Immunization Registry requirements. They are under the waiver that, that some have been operating under. And they already have to comply with federal vaccine reporting requirements. So we're just simply making it specific to dental practice, but it doesn't change the fact that the dentists have to have documentation somewhere of that information. Now, we have it exist training, we have it that they have to have it on premises. You could change that if you don't want them to have to maintain their record on premises, but that's kind of your current practice when it comes to these types of documents. But the only thing that's, like I said, different is that the training requirement would have to be on premises. And so the other records would have to be available for inspection. That's the only thing.
Well, see,
So
that we would not have
the
that document. Yeah, I'm sorry. We would not have that documentation on premises if we were volunteering for somebody else, for county health services or for medical facility, placing vaccinations. We wouldn't have that on premises. But maybe we can just clarify that it's on premises at the other location. Or it just seems like it might need a little bit of clarification to volunteer vaccinators.
Okay, so the premises requirement is for training certificates.
Okay.
The other information is that it has to be readily retrievable during normal business operating hours. It doesn't say on premises. Wherever the information is stored, it has to be available to the board for inspection. So that's the question would be, is that a difficult requirement to meet? Now, this is a current standard that pharmacists meet, and they don't seem to have any issue with meeting this requirement. I'm not sure what the complication would be for requirement.
Well, no, for CE, it's fine. For CE, it's fine. We would have it on premises. I was just thinking about the
staff. Okay, because I just want to make sure that staff are in agreement with that assessment.
Or council, I just wanted to point out that this is primarily for administration of vaccines in office, not on voluntary terms. So to the extent dentists have been voluntarily administering the COVID-19 vaccination, they're probably doing so under an executive order. So if they continue to voluntarily administer the COVID-19 vaccine, they would be doing so under a different law, not under the Dental Practice Act. And these regulations are only fleshing out the new authority under the Dental Practice Act to administer in the dental office.
Yeah, yes, that's what I thought, and that's exactly what I was talking about. Now, can we refer? I mean, is it possible to clarify that somewhere? Just for because I wouldn't know that. I wouldn't know it's under a different law. And I would just think that I have to do the same thing when I'm volunteering, if I read the Dental Practice Act.
So,
I guess, go ahead, Christy.
So, I'm not sure what under law they would be operating under after and against adding that clarification, because I think that if you're independently prescribing and administering, no matter where you are located, regulation. So the question is are they independently administering, or are they doing it under someone else's supervision? Because that's what independence means. You're doing it without someone else supervision. You're doing something without any oversight from anyone else, that they have to comply with this section. That's the way I interpret it.
Yeah. Well, yeah, that's exactly what happened when I was volunteering. There had to be either a dentist or a physician on there present, and I was sometimes the physician. I mean, the dentist that was in charge. So that would apply. So even though we're not recording everything, all the vaccines ourselves, in our independent practice, we were supervising other people. It's a little tricky there, so just think about it.
Are you okay, Dr. Loreen?
Well, not really, but I mean, if we just need to get this going, so I'll be fine with it. We just need to think about this.
Ms. Welch, did you have another comment?
This is Tara Welch, Board Counsel. Everyone was administering COVID-19, or dentists were under the DCA orders, which either have already expired or will be expiring once the state of emergency is over. So there really is not going to be any statutes to cross-reference, because right now it's just executive orders and DCA orders. So I think this is as good as it gets as far as statutory authority for dentists. Going forward with voluntary administration, I don't know that you're actually going to have any authority to do that. And if so, it's probably under Health and Safety Code, which we have not researched because we're solely focused on implementing this new bill that centers the administration of these vaccines in the dental office. So I think my point here is I think it's probably, you need to get moving with this regulation, this rulemaking file, to the extent you want to continue to voluntarily administer outside of the dental office. I think that's a different question for the legislature, and it's not going to fall into these executive orders anymore.
Thank you, Ms. Welch. Are there any other comments about the reg package that we're submitting?
Alan, this is Steve Chan.
Yeah, how come I don't see it? Yeah, it's supposed to be coming up. All right, Dr. Chan, go ahead, sir.
This is Steve Chan, and I do advocate initiating this emergency rulemaking and initiating the rulemaking to adopt the code relating to initiating and administering vaccines. Just as background, I was part of a vaccination team early in 2021 when the vaccine was first being administered. But I'm also on the governing board for my regional hospital. So realized that we had a certain content of knowledge back in 2021 early on, and especially with COVID-19, it kept evolving and kept modifying as we learned more about how to do this. I would probably suggest that we consider doing this initial format and initial rulemaking, and then modify as we move forward, as we know more of the shortfalls. Whenever we have humans delivering this end product, there are a lot of variables that come into play, and we've learned a lot of the variables in that hospital governing board. But that should come downstream so that we can at least get the base getting started, and then we can react to it as maybe a new variant comes into play. So again, I would advocate that we get started on this, adopt this, or consider adopting this now as the base, and then as we identify other shortfalls or gaps in what we know, then implement those as we move forward. Thanks.
So Dr. Chan, you're going to be making a motion then that we adopt all this?
I'd like to, yes, and we're going to bundle it, right, Dr. Felton?
I would like you to read both paragraphs into the records, and then that will be your motion. Thank you.
Okay. I'd like to move that we initiate an emergency rulemaking, adopt regulations and finding of an emergency, and initiate a regular rulemaking to adopt California Code of Regulations, Title 16, Section 1066, relating to dentists initiating and administering vaccines. I'd like to move that.
What happened to the rest of all those options 1 and 2? Did you not read all that? I'm not sure what you're reading.
I only have option number 1. I don't have that in front of me. I only have what's in front of me.
You don't have the supplemental document that came in then.
I just got it at 11 o'clock. Believe it or not, they just delivered it at 11 o'clock.
Council, are we going to be okay with, why don't we just do it this way? If there is no objection, on page 3 of 34 of the supplemental materials, which includes all of the information on the regs, there are 2 paragraphs, and we will, in the minutes, we will record that the motion is to accept paragraphs 1 and 2, and that would be the combined motion, because I don't think Dr. Chan had all that.
Oh, actually, I do have it, if you want me to read it.
Do you see it there?
Yes.
Then read it very quickly, please, if you will, so that we have it in the
Number
record.
1,
Thank you.
we recommend that direct staff to take all necessary steps to complete the emergency rulemaking process, including the filing of emergency rulemaking package with the Office of Administrative Law. Authorize the executive officer to make any non-substantive changes to the proposed regulations and adopt the finding of emergency and the proposed regulatory language as written in the order of adoption. If no adverse comments are received and the text is approved by OAL, authorize readoption as needed and authorize the staff to take all steps necessary to complete the regular rulemaking process to make the regulations permanent and adopt the proposed regulations at Title 16 CCR Section 1066 as noticed. Number 2, if OAL or another control agency disapproves the emergency rulemaking, direct staff to submit the proposed text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the regular rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day public comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at Title 16 CCR Section 1066 as noticed.
Thank you, Dr. Chan. Is there a second? Dr. Morrow?
Morrow
right.
seconds the motion.
Thank you, Dr. Morrow. You don't have to read it again. Is there any further board discussion on the motion? And Dr. Morrow, I assume you're going to put your hand down at this point, yes?
Yes.
All right, thank you. Okay, is there any public comment on this motion? Moderator, please facilitate public comment.
This is the moderator. We've opened that Q&A panel. If you'd like to comment on the motion before you regarding the emergency regulatory package, please click on the Q&A icon on your screen, type comment into the text field, and submit that to our panelists. If you are a call-in user, you may raise your hand by dialing *3. And as a reminder, all comments need to be directly related to the agenda item currently being discussed, or your microphone will be muted. Our first comment comes from Dr. Bruce Witcher. Dr. Witcher, I've sent the request to unmute your microphone.
Bruce Witcher on behalf of CDA. I'd just like to support this proposal and thank you for bringing this forward and conducting this rulemaking so promptly. Thank you very much.
Thank you. Our next comment comes from a call-in user. Call-in user, I've sent the request to unmute your microphone.
So in terms of any emergency renderings by the dental board for risk to the public health and safety, I am speaking to Borrego's internal fraud investigators today for the 6th time about evidence that you, the dental board, refused to take from me, including...
Dr. Tuso, if you have nothing to say about this particular emergency regulation packet, then we're going to have to mute you. I'm sorry.
And seeing no additional requests for comment, would you like me to close the panel?
That will be fine. Thank you. Board Secretary, we're not going to make you read this one because it's already been read into the record. Would you like to take the roll and record the votes for this agenda item?
Yes, Mr. Secretary. This is Dr. Molina, Secretary. Dr. Chen. And I, Felsenfeld.
Felsenfeld, aye.
Felsenfeld, aye. Larin.
Lorraine, aye.
Lorraine, I. Mackenzie? Mackenzie, I. Medina?
Medina, I.
Medina, I. Molina, I. Montel? Montel, I. Morrow?
Morrow, I.
Morrow, I. Olagi?
Olagi, aye.
Olagi, I. Pacheco? Pacheco, I. You?
UI.
You, I. Motion passes.
Thank you, Dr. Molina. This is going to conclude the March 14th, 2022 board meeting. I want to thank the moderator, thank our staff, thank the board and the public members. This meeting is now adjourned.